The woman's name is protected in parts of the public record, so the Marshall Project, which broke this story, refers to her by her role and her documented history. She is an emergency room nurse, 39 years old. She has lived in Central Florida for nearly 2 decades, long enough to raise a daughter here, long enough to be the person coworkers call when a shift goes sideways at 3 in the morning. She is also, on paper, removable. That word is the hinge this whole story turns on. Under U.S. immigration law, a person can hold a job, pay taxes, carry a nursing license issued by the state of Florida, and still fall into a category ICE can act on. The nurse's status had lapsed years earlier through a paperwork channel most people never think about. She kept working. The hospital kept employing her. The gap in her file sat quiet, invisible, until the day she chose to do something almost nobody in her position does willingly. She walked into a police station and offered to help. Here's what she knew. In the spring, a violent assault had rippled through her community. The kind of case that fills an ER waiting room with frightened families and fills a detective's whiteboard with dead ends. The nurse had treated someone connected to it. She had seen something, names, a timeline, a detail about an injury that didn't match the story police were being told. Detectives in the Osceola County Sheriff's Office had a case going nowhere. She handed them the thread that unraveled it. Think about what that takes. She is undocumented. She knows that every interaction with law enforcement is a risk. She walks in anyway, sits across a table from a detective, and gives a statement that helps build a case against a genuinely dangerous person. For a few weeks, she is exactly what the system says it wants. A cooperating witness, a good neighbor, the reason a violent case gets solved. Consider what she carried in with her. An emergency room nurse sees the aftermath of violence in a way almost no one else does. The wound a weapon leaves, the injury a fall doesn't cause. Her observation wasn't a hunch. It was clinical. She knew the mechanism of the injury contradicted the account being given, and she knew it with the authority of someone who has closed 1,000 lacerations under fluorescent light. That expertise, the thing that made her valuable to detectives, also placed her name at the center of a felony file. Then the machinery she trusted turned around and looked at her. To understand how, you have to understand what happens to a name once it enters a law enforcement system in Florida. When the sheriff's office processed her cooperation, logged her identity, ran her through the standard checks that come with any witness statement in a felony matter, her information passed into shared databases. Not one database, a web of them. Local booking systems in Florida feed into state records, and state records get cross-referenced against federal systems, including the biometric and biographic networks ICE queries every single day. The bridge between a local sheriff and a federal deportation officer isn't a phone call anymore. It's a server. Osceola County, at the time, operated under a 287G agreement, a formal partnership authorized under Section 287G of the Immigration and Nationality Act that lets designated local officers perform certain immigration enforcement functions and flag individuals to ICE. Under the specific model in use, jail and records staff screen the immigration status of people who pass through the county's system. The program gets pitched to the public as a tool for removing violent criminals. The nurse was not a violent criminal. She was the witness against one. But 287G screening doesn't weigh why your name is in the system. It weighs whether your status is removable. Hers was. The obvious question is why a witness would ever be treated the same as a suspect. The answer is simple and uncomfortable. In database-driven enforcement, there is often no field that says, "This person is helping us." There's a field for identity, a field for status, and a field for whether a match generates an alert. When her biographic data cleared the felony witness intake, it also cleared the immigration status query. The match came back. An alert went out. The system never paused to read the case file. Somewhere in an ICE Enforcement and Removal Operations Office, a detainer or a target packet began to take shape around a woman whose only recent contact with police had been to help them. She didn't know any of this. She went back to work. She picked up shifts. She told a coworker, quietly, that she was proud she'd done the right thing. The detectives had what they needed. The dangerous man was in custody. As far as she understood it, her part was over. It was over. That was the problem. The system had already moved on to her. You might wonder why ICE would even bother. By the agency's own reporting, there are millions of people in removable status across the country. Enforcement resources are finite. Deportation officers prioritize. So why this woman, with no conviction, no violence, no record beyond a lapsed status? Because she was easy. She had done the one thing that makes a person findable. She had raised her hand. That's the quiet brutality at the center of this case, and it deserves to be said plainly. A cooperating witness has volunteered their exact identity and location to the state. She had given detectives her name, her address, her workplace, her phone number. She had made herself the most locatable person in the entire investigation. When the database flagged her, ICE didn't have to hunt. They already had the map. She'd drawn it herself, in good faith, on a witness form. The morning it happens is an ordinary Tuesday. 2 SUVs at the curb, agents in plain clothes with badges on lanyards, the flat calm of people who do this constantly. They confirm her name in the driveway. No chase, no barricade. There's a woman in scrubs, keys in her hand, being told to put her bag down. She asks the question everyone asks. She asks if there's been a mistake. There hasn't been a mistake. The system is functioning exactly as it was built to function. She's taken into ICE custody and processed into the immigration detention pipeline, the network of county jails and privately operated facilities ERO uses across Florida and the Gulf Coast. In detention, an immigration case is not a criminal case. There's no right to a free attorney. The burden tilts against the person in the jumpsuit. She's now expected to prove, from inside a locked facility, why a country she's lived in for nearly 20 years shouldn't remove her from it. And the case she helped solve moves forward without her. She becomes a footnote in a prosecution she made possible. Her attorney, retained by co-workers who pooled money once word spread through the hospital, files the obvious argument first: prosecutorial discretion. There are, on paper, protections and visa categories built for people in her situation. The U visa, created under the Victims of Trafficking and Violence Protection Act of 2000, is designed for victims of certain crimes who assist law enforcement. There are humanitarian pathways for material witnesses. Buried in its own statutes, the system acknowledges that people who help solve crimes shouldn't be punished for it. Getting to those protections from inside detention is another matter entirely. Here's the first wall. A U visa generally requires certification, a signed form from a law enforcement agency confirming the person was helpful in the investigation or prosecution of a qualifying crime. That signature is discretionary. No agency has to provide it. So the nurse's fate now depends on whether the same sheriff's office that fed her name into the database that flagged her will now sign a document acknowledging she was, in fact, one of the good ones. The request goes to the agency, and it sits. That's not a delay tactic in the movie sense. It's simply how the process moves, slowly, through inboxes, across desks, while the person waiting sleeps on a detention bunk and counts days. Her daughter, a US-born teenager, stays with a coworker. The hospital holds her position as long as HR policy allows. Colleagues start a fund. A local reporter starts asking questions. And the Marshall Project, a nonprofit newsroom that covers the criminal justice and immigration systems, begins reconstructing how a cooperating witness ended up in a deportation proceeding. What they find isn't a single villain. It's a seam. The real story isn't a rogue agent or a cruel detective. Every person in this chain followed policy. The detective logged the witness the way any felony statement gets logged. The records clerk ran the standard screening the 287G agreement requires. The ERO officer acted on a valid database hit. The detention facility processed a lawful detainer. Nobody broke a rule. The harm came entirely from rules working together as designed, and that's a far harder thing to fix than a single bad actor, because there's no one to fire. Sit with that. No one did anything wrong, and a woman who helped catch a violent criminal ended up in a cell for it. Once the story becomes public, the escalation is procedural and grinding. Her attorney requests a bond hearing before an immigration judge. Bond in immigration court isn't guaranteed. The judge weighs flight risk and danger to the community. Her lawyer's argument writes itself. This is a woman who voluntarily walked into a police station, a person with a 2-decade history in one community, a licensed nurse, the mother of a citizen child. If she were a flight risk, she'd never have handed detectives her home address. The government's position is narrower. She's removable. She has a lapsed status and no final protective ruling. Those are the facts the statute cares about. You start to see the shape of the trap. The cooperation that should be her strongest argument for staying is the reason she's detained at all. Her helpfulness is both the shield and the thing that got her caught. The bond question hangs. Meanwhile, the U visa certification request continues moving through the sheriff's office at its own pace, and the clock inside detention keeps running. Days become weeks. This is the part of these cases that never makes a thumbnail, the sheer duration of the waiting, the way a person's life gets put on hold while forms travel between agencies that don't talk to each other in real time, even though their databases do. There's a bitter symmetry to that. The systems share data instantly when it comes to flagging someone for removal. When it comes to paperwork that might save her, everything slows to the speed of a mailed form. The obvious counter-question is whether she could simply be released and told to check in later. In immigration proceedings, that does happen. Release on recognizance, ankle monitoring, supervised release through ERO's Alternatives to Detention program. Those options exist. Whether they're offered depends on discretion, on facility capacity, on the specific posture of the case, and on the judge. For the nurse, detention is the default, and default is a powerful current to swim against. The reporting traces her through this pipeline in careful, sourced detail. The intake, the transfers between facilities, the phone calls rationed by the minute, the daughter's visits behind glass. A woman who spent her career keeping strangers alive in an emergency room is now the one waiting, powerless, for someone with authority to decide whether she gets to stay. Consider one detail the reporting captures about those visits. The daughter, a teenager, is old enough to understand exactly what's happening and too young to do anything about it. She sits across the glass from a mother who used to work overnight shifts and still made it to school events, and now the two of them speak through a handset on a metered clock. When the minutes run out, the call ends, sometimes mid-sentence, and the girl goes back to a coworker's spare room. That's the domestic cost of a database match. A child rearranged around a parent's absence, a household rebuilt on borrowed furniture and pooled paychecks. There's a professional cost, too. The hospital that employed her didn't just lose a name on a schedule. It lost a nurse who knew the rhythm of a trauma bay, who could read a room full of frightened families and calm it. Her colleagues covered her shifts, and in covering them, they felt the gap, the reminder that the person the state was detaining was the same person they'd trusted at the worst hours of their own worst nights. This is where the story forks into the version the system prefers and the version that actually happened. The version the system prefers is that the safeguards worked. The U-Visa framework exists. Prosecutorial discretion exists. A good attorney and a sympathetic set of facts exist. In a functioning process, all of that combines and the cooperating witness gets protected, and everyone points to her as proof the machinery has a conscience. The version that actually happened is messier. Cases like hers sometimes end in relief, a certification signed, a bond granted, a case administratively closed. They also sometimes end in removal, a person put on a plane despite everything because the discretionary pieces never lined up in time. The Marshall Project's reporting places her not as a lone freak accident, but as one example of a documented pattern. Witnesses and crime victims drawn into immigration enforcement through the same local federal data sharing that 287G and shared biometric systems create. She's a case study in a design flaw, and the flaw isn't hypothetical. Which brings the whole thing back to the driveway. Back to 6:40 in the morning, teal scrubs, keys in hand, 2 SUVs at the curb. Remember what she thought that morning? That the hardest part of her year was behind her. That helping the police had been the right thing. That her part was over. Every one of those beliefs was reasonable. Every one of them was also, in the logic of the system she'd trusted, naive. She had assumed cooperation would be read as an asset. The database read it only as a location. Think about the message that sends, and not to her, to everyone standing behind her, to every undocumented nurse, dishwasher, construction worker, and mother who witnesses a crime and considers coming forward. Strip her case to the wire, and the lesson is that the safest thing an undocumented witness can do is say nothing. Detectives across the country rely on exactly those witnesses to solve exactly these crimes. When cooperation becomes a trigger for removal, the people who lose aren't only the immigrants. They're the neighbors whose cases go unsolved because the one person who saw something decided the risk wasn't worth it. That's the operational cost buried inside this single story. A crime got solved because she talked. The next crime may not, because she was punished for it, and word travels. Her case, at the time of the reporting, remains unresolved, the way real cases usually are. No clean verdict, no music swell, a certification request still pending, a bond argument still live, a daughter still waiting. The Marshall Project laid out the mechanism in full. The 287G agreement, the interlocking databases, the biometric queries, the discretionary signatures, the detention default. Not to argue a policy, to show, step by step, how a person can do everything right and still end up on the wrong side of a locked door. Here's the detail that captures the whole weight of it. The man she helped put away is exactly where the system wanted him, removed from the street, held to account, a genuine danger neutralized. The system worked. It just also came in the same motion, for the woman who made that possible. She unlocked her car at 6:40 that morning, believing she'd helped make her community safer. She had. That was never in question. The only question the system ever asked about her was whether she was removable. The answer on paper was yes. The truth was something no database has a field for.